Good morning and good afternoon, everyone. Welcome to the 2025 Year in Review for Labor Law. So thank you to those of us who are joining us from across the country. Welcome back to those who have joined us in prior years. Before getting on the call, we're reminiscing about years gone by and how many times we've done these year in review sessions. So thanks again to those loyal followers who have been with us year after year. My name is Erin Porter. I'm a partner in the Toronto office. In my practice, I advise clients on various labor and employment matters and spend a fair bit of time before arbitrators in the Ontario Labor Relations Board. Before I introduce my co-presenters, I just want to go over some housekeeping. So first of all, you will see on the slide that the materials will be available and can be downloaded in the handout tab. Questions, please feel free to type them into the Q&A box and we'll do our best to try and get to them. Please take some time to fill out the survey, particularly if you have some nice things to say, and if you have any requests for sessions in the future, then we also love to get that feedback as well. And then you can also get your CPD certificates through the QR codes, and you can find that information on the tabs, various tabs throughout the session. So with that, joining me today, I have Emilie Paquin-Holmested, who is both a partner in our Montreal office, as well as the co-leader of Fasken's Labor, Employment and Human Rights Group nationally. Her practice is primarily focused on federal and provincial labor relations, employment law, human rights law, and pay equity. In addition to providing strategic and preventative advice, she represents clients in litigious matters before the civil courts and administrative tribunals. And she is a frequent flyer in our speaker series, as she got to speak last week in our federal sector session. So thanks to Emilie for joining us again today. And then all the way out on the other side of the country, we have Jordan Thompson joining us, who's a partner from our Vancouver office. Jordan provides strategic guidance to employers on a variety of workplace issues and regularly represents unionized employers in labor arbitrations, mediations, collective bargaining, and before the BC Labor Board. Jordan also assists non-unionized employers in a range of matters, including wrongful dismissals, post-employment obligations, employment standards compliance, and human rights issues. So you've got a great panel here today, and with that, we will get started with our presentation. So you'll see that there's an agenda here before you that talks about the items that we're going to go over. We're going to talk about the ban on replacement workers, disciplining for harassment when we're talking about union representatives, the union's freedom of association, and then finally, what to do about production of documents and evidence in the arbitration context. So with that, we will begin with a ban on replacement workers and essential services. I'm going to start by briefly talking about the changes in the federal sector, although I won't spend a lot of time on this because I know that it was something that was discussed in last week's session. And if you're interested in last week's session and would like to hear more federal content, the link to that webinar is going to be dropped into the chat. So please feel free to download that. And you can watch our colleagues who presented last week. So I think it was Chris Piggott, Jackie Vandermeulen, and Emilie were the presenters and have a lot of great insight about the federal sector. All right. So if you're part of the federal sector, then you've probably heard that Bill C-58 came into force in the last couple of months on June 20th of 2025. And this legislation changed the ability for employers to be able to rely on replacement workers. So essentially, it now prohibits replacement workers, and that includes any employee, including non-union employees and management that are hired after the notice to bargain, as well as any employees hired before the notice to bargain, if that employee normally worked at a different location. So you can't bring in employees from other locations if you have them during a strike or a lockout. This does not apply to managers. So managers from other locations are still able to come, as long as they were hired before notice to bargain, are still able to come and assist. Any contractors, if hired before the notice to bargain, and they can continue with the same work. Now, there's a lot of debate about what that will mean and what the scope of that will be. There are no reported decisions yet, but we know that that is something that's already been being tested at the Labor Board. And then any volunteer, student, or member of the public. So it narrows fairly significantly the ability for employers to try and manage their workplace during a strike or during a lockout. With the ban on replacement workers also comes the requirement for protecting essential services. So unions and employers now must enter into what they're referring to as a maintenance agreement or a maintenance of activities agreement within 15 days of giving notice to bargain. And so they have to determine, what are the essential services and what operations must continue in order to ensure the health and safety of the community. Anecdotally, what we're hearing is now this means that actually the parties are spending all of this time at the beginning trying to negotiate this maintenance agreement rather than actually focusing on bargaining and trying to come to a resolution of the collective agreement. So, again, what we're hearing sort of and seeing anecdotally from our clients is that, if anything, it's almost delaying the start to meaningful bargaining because there's this obstacle that's been put in the way under the new legislation. And then if the parties are unable to agree, then the CIRB will issue a decision within 82 days of the application to the board. The violations are considered to be an unfair labor practice, and the fines of up to $100,000 per day for violations can be awarded. As I mentioned, there currently aren't any decisions from the CIRB, so we're not sure how broadly or narrowly things will be interpreted. But what we can say is that there have been lots of applications to the board. And in fact, the first application, I think, was received on June 23rd. So 3 days after the legislation actually came into effect. Now, there was no decision in that case because the parties were ultimately able to conclude bargaining and agree upon a new collective agreement. So we don't have any sort of insight yet, but I know one of our colleagues, Ian Campbell, just finished arguing a case before the board last week. So, we do expect to start seeing decisions fairly soon. A lot of this legislation does sort of get its foundation and its basis from the legislation that will now be discussed that come out of Quebec and out of BC. So I'll turn it over first to Jordan to talk about replacement workers in British Columbia.
Yes, thank you, Erin, and thanks everybody for joining us this morning and this afternoon. So at this point, a lot of you might be familiar with the Gate Gourmet decision line of decisions coming out of BC in relation to the scope of the replacement worker provisions and particularly the impact of those provisions outside of the geographic area of BC. So the original 2022 decision from the Labor Board has now gone through the reconsideration process at the board. It's been judicially reviewed in the BC Supreme Court. And a few months ago, the BC Court of Appeal has now issued its decision in this case. So for a quick factual background on how the issue arose before the Labor Board, Gate Gourmet essentially provides catering and hospitality products and services in Canada, airline catering and hospitality products and services in Canada, such as the preparation of food to go on its on flights. Gate has operations in different provinces, which provide these services to airlines in those jurisdictions. So you have GATE as a single corporate entity, and then various local operations where the catering type services are performed. GATE's employees at its YVR operations commenced a strike via an overtime ban. And in response to that, one of GATE's customers, Air Canada, requested that GATE start double catering flights from other locations, such as Alberta and Ontario. And so what double catering meant is that GATE workers, for example, in Toronto would prepare meals to go on a flight from Toronto to Vancouver, and then also would prepare meals to come on the return flight from Vancouver back to Toronto. The union challenged this approach and said it was a violation of the replacement worker provisions under the BC Labour Code. And so the operative provision of the BC Labour Code is Section 68(1), which, and this is a paraphrasing of the full provision of the code, but essentially it provides that during a strike or lockout, an employer must not use the services of a person who ordinarily works at another of the employer's place of operations to perform the work of an employee in the bargaining unit that is on strike or is locked out. So another way to look at this is whether an employee of the employer at another location is doing the work that would normally be performed by a striking employee, but for the strike. So there were a number of arguments, and obviously I'm covering this at a very high level. There's a number of very complex arguments before the Labor Board, including that GATE's YVR operation, rather than GATE as a single national entity, should have been considered the employer for the purposes of the BC Labour Code. Also, that GATE was simply responding to a client engaging in what's referred to as self-help, and this is referring to Air Canada's request for GATE to perform double catering work. And then finally, the argument which ended up before the Court of Appeal in BC is that the code cannot have an extra provincial impact and regulate the performance of work outside of the province of BC. The Labor Board, in first instance, agreed with the union and said that what occurred was a violation of the replacement worker provisions. And this was upheld on reconsideration at the board, and it was also upheld on judicial review by the BC Supreme Court. And on appeal before the BC Supreme Court, the issues were whittled down, and the main issue became whether the board's interpretation of the replacement worker provisions in the code resulted in an impermissible application of BC labor law on individuals and activities occurring outside of the province. Or in other words, if the board's order preventing GATE from doing this double catering work exceeded the board's constitutional jurisdiction. In order to answer that question, the Court of Appeal applied what is referred to as the sufficient connection test, which has been developed by the Supreme Court of Canada. And I won't go through the test and the factors in detail, but essentially what the court is asking is to conduct an assessment of a number of factors which are meant to determine whether the provincial legislation has an impact outside of the province and whether the degree of that impact is acceptable or not. So in conclusion, in conclusion, the Court of Appeal agreed that the board's order did not result in impermissible impact outside of BC, and that any such impact was simply incidental to the board's proper application of the code. And so the Court of Appeal noted the following at the end of the decision. They quote, "The company relies on a unionized British Columbia workforce to provide services to customers in BC. It has availed itself of the British Columbia labor market and is obliged the company is obliged to comply with, quote, the rules of the game. These rules include a prohibition against the use of replacement workers to perform struck work. The board determined that on a proper interpretation of the code, The employer's actions in facilitating a customer's request to move struck work to employees in other jurisdictions was a violation of the replacement worker provision. The fact that the other place of operations where the work was reassigned happened to be outside of British Columbia does not alter the assessment. And so in terms of takeaways from this case, while many employer side, in particular lawyers, disagree with the outcome, the Court of Appeal has now confirmed that what we understood to be the law in BC since at least 2022 is that the replacement worker provisions can apply to work being performed outside of the province. The GATE decision has a significant impact on multi-jurisdiction employers in particular. Those are obviously those who are doing business in BC. The major impact's going to come in the way of strike contingency and business continuity planning. Historically, employers doing business in BC could hypothetically mitigate the effect of strikes or lockouts by redirecting some of that work outside of the province, as the code did not apply outside of the geographic scope of BC, which is no longer the case. There also is, of course, the potential for this decision to carry some precedential weight into other jurisdictions. We are seeing a trend across Canada generally of more regulations and more restrictions regarding replacement workers, as Erin was just covering the federal area, and Manitoba has also recently introduced a ban on replacement workers in their legislation. One final comment, though, all is not lost potentially yet. I understand that the Court of Appeal decision is pending leave to appeal at the Supreme Court of Canada. So there might be a final word on this issue forthcoming. But as of right now, this is the law in BC as it relates to replacement workers. And so I will pass it over to Emilie now to talk about Quebec.
Thank you very much, Jordan, and good morning, good afternoon to everyone joining. Just a few words regarding ban on replacement workers and also on essential services rules in Quebec. In the last few years, there have been quite a few changes. Before speaking about the essential services, I'd like to do a quick update on the ban on replacement workers saga that we've been having in Quebec since 2021. So since 2021, employers in Quebec have been waiting to know what will happen with the rules relating to the ban on replacement workers. We're wondering whether they'll remain the same as they've existed for many years, or whether they will evolve as was decided by the Labour Board back in 2021 in two very well-known cases, which is the Group CRH and Co-op Novago files. So just a quick recap. As many of you know, in Quebec, since the 1970s, we have had rules on the ban on replacement workers. These came into force at a time where there was a lot of violence and strife on the picketing lines. And so the rules in Quebec have always revolved around the notion of establishment. And the reason for that was to prevent violence on the picket lines. Therefore, the ban on replacement workers in Quebec has always because it's been based on the notion of establishment, most of the ban prevents different categories of people from doing replacement work inside the establishment, but then allows different categories of people from doing replacement work outside the establishment. In 2011, the Court of Appeal in Quebec confirmed that the notion of establishment was the physical location where the employer locks the door during a labor conflict, even a context where many employees on strike were regularly doing their work outside of the establishment. However, in 2021, in a context of forced remote work during the pandemic, the Labour Board came and revisited or expanded the notion of establishment to include the notion of deployed establishment, which includes employees from the establishment on strike who are working remotely. Obviously, the consequences of the deployed establishment is that it greatly limits employers from having replacement workers do some work outside of the establishment that's on strike. This decision was later confirmed in a second decision by the Labour Board in the Co-op Novago case. Both decisions went to judicial review in 2023. Superior Court rendered two different decisions, and now the Group CRH decision is appealed and was heard before the Court of Appeal in May 2025. So we're expecting a decision on this very important topic in the spring of 2026 rather. So it'll be interesting to see whether the Court of Appeal will maintain its decision of 2011, where they confirmed that the establishment was the physical location where the employer locks the door, or whether they will adopt this new interpretation of the notion of establishment as established by the board back in 2021. And in parallel to these decisions on the ban on replacement workers, during the last few years, the Quebec government has been passing laws that aim to limit the impact of strikes in certain very specific situations. For example, in 2019, the Labor Code was amended to expand the notion of public services that can be subject to essential services rules in Quebec to services that are comparable to public services. Therefore, the specifically enumerated public services in the Labor Code, and now the comparable public services must maintain essential services if a strike can endanger public health or safety. So to be clear, it is not all public services or all comparable public services who must maintain essential services during a strike. It's only those where a strike could endanger public health or safety. Therefore, since 2019, there's only been a handful of employers who have been found to be considered comparable to public services. It's mostly in health and social services sectors that we've seen this. And an even smaller number of employers have been required to maintain essential services. So one of those rare examples was the safe injection site Maison Benoît Labre, in which the board found earlier this year that the safe injection site was both comparable to a public service and was also subject to the essential service rules because the strike could affect the public health and safety. Therefore, despite the legislative change, which aimed to limit the impact of strikes in a greater number of services and situations, Quebec has continued to be affected by a tremendous number of strikes in both public and non-public services, many of which had significant impact on the population. This brings me to Bill 89. So earlier this year, in May 2025, in addition to the essential services rules in Quebec, and in response to the significant number of strikes in Quebec, the government passed Bill 89, which provides for the maintenance of services to ensure the well-being of the population. So what are services that ensure the well-being of the population? They're defined as being services minimally required to prevent the population's social, economic, or environmental security from being disproportionately affected, in particular that of persons in vulnerable situations. So the bill applies to all employers except in public sector and the health sector, and is described as being complementary to the essential services rules. Therefore, it has a broader reach than the essential services rules, which provides that only public services or services that are comparable to public services must maintain essential services if it can endanger public health or safety. In the case here of the maintenance of services to ensure the well-being of the population, it's provided that the government will identify by decree which employers and unions could be subject to this new rule. Then the Labor Board will determine whether certain services must be maintained to ensure the well-being of the population. And similar to the mechanism for essential services, the parties will then have a few days to negotiate what those services are. And if no agreement is reached, then the board will decide what the services that have to be maintained are. However, it remains unclear how the notion of services minimally required to ensure the well-being of the population will be interpreted. This new bill also allows the Minister of Labour to refer a dispute to an arbitrator if the minister is of the view that a strike or lockout threatens to cause serious or irreparable injury to the population. So this is considered an exceptional measure that can only be used after conciliation's failed. This last part of Bill 89 appears to be very inspired by the federal minister's powers that are provided for in the Canada Labour Code to send a dispute to arbitration, which has been used a few times in the last few years, including in the railroad saga. I believe that was last year. So Bill 89 provides that it's supposed to come into force on November 30th, so in a few weeks. However, during the recent public transit strike in Montreal, which was supposed to last all of November and greatly affected public transportation in Montreal, the Quebec government tried to pass a bill to have Bill 89 come into force before the November 30th date. So the bill has received enormous pushback, and obviously this new bill, to have it apply ahead of time, did not receive the required support from government, and there has been some agreements in principle in some of the main unions in the public transit and the Montreal Public Transit Group. Therefore, it appears like the November 30th date will be the date that this will come into force. Obviously, this bill has received enormous pushback from all major unions in Quebec. There's also a group of recently unionized McGill faculty associations who have already contested the bill before the Superior Court, alleging that it is unconstitutional. So those are the updates in the last few, and this year and the previous years, regarding the ban on replacement workers and essential services in Quebec. Now I'll pass it back to Jordan to discuss discipline and disciplining for harassment of union representatives.
Thank you, Emilie. The first case we're going to be looking at under this theme deals with a discipline decision that occurred in the context of misconduct during a work stoppage, and in particular on a picket line. So not in relation to a union representative per se, but certainly a member of the union who was a very vocal and prominent member of the union in relation to the picketing activities, and a leader of the the workforce generally. This case involved the termination of a lead hand who had worked for the employer for over 15 years. So very, long service employee, and no prior discipline or other aggravating issues in his record. The misconduct itself arose in the context of a prolonged work stoppage. And the employee engaged in two types of misconduct. The first type related to the harassment of a truck driver who was crossing the picket line, and the second related to what the arbitrator described as sexual harassment of a security guard who was hired on the employer to monitor, the picketing activities in the usual course. With respect to the truck driver, what the griever had done was he swore at the truck driver in Punjabi while he was crossing the picket line, said statements to him to the effect that he had no shame and that he was taking food off of the tables of the striking employees. Certainly the other misconduct relating to the security guard was the much more egregious of the two that the arbitrator considered. The security guard in question here was a 20-year-old female. The griever used a megaphone and made comments to the effect that the security guard was really good looking or very beautiful, and repeatedly demanded that she smile for him and the other employees on strike. The arbitrator found that the griever had premeditated these acts, as he had asked one of his coworkers to film the interaction so that he would have evidence of it occurring. Not exactly sure why he thought that was a good idea, but that's what happened. And then following this, the griever also encouraged another employee to target the same security guard with similar kind of sexually suggestive commentary. At the end of the work stoppage, the union asked the employer to forgive any conduct of the employees that occurred in the heat of the picket line. The employer did agree to do that, except for a few specific incidents that it referred to, and this was one of them. And so in upholding the termination, the arbitrator determined that the griever's actions were, quote, egregious workplace misconduct. And he focused on the impact of the griever's actions on the security guard directly. And so the quote from the arbitrator is as follows. I have no difficulty at all concluding that the griever's actions towards the female security guard constitute sexual harassment. The griever set out to deliberately demean, belittle, and embarrass her in a sexualized manner for the amusement of his colleagues. He treated her as an object for him to manipulate rather than the professional she was. I accept the griever's conduct was demeaning, hurtful, and had a profound affront on her dignity as an employee, a professional, and as a human being. That conduct, to put it bluntly, has no place in a modern workplace. The arbitrator did, focus in on the fact that of the context of this occurring. So, the fact that the workforce was 90+% male, and the griever with his comments was targeting a young, female security guard who was, by all accounts, there to just, do her job. The union advanced an argument that, the arbitrator ought to consider the circumstances in which this misconduct occurred, in particular, the fact that it occurred in what was referred to as, the heat of a strike or the heat of the picket line. But the arbitrator did, readily reject this argument in these circumstances. And another quote from him as follows. To the extent the union argues I should consider the griever's conduct as it pertained to the security guard incident in the context of a strike, I am not persuaded that constitutes a mitigating factor in these circumstances. While I appreciate that tempers and emotion may run high on a picket line and that may, in appropriate circumstances, be taken into consideration when assessing aggressive picket line confrontations, for example, I find that the union has not established why or how being on strike or on a picket line might contribute to the griever's decision to sexually harass a security guard. The arbitrator also found that the griever lacked remorse and that the apology he did offer her was superficial at best. Ultimately, this led the arbitrator to conclude that there was a high risk of future workplace misconduct if the griever were to be reinstated. So I think, takeaway here is really kind of two things, right? So we have an arbitrator providing a good example of taking a very strict approach to, imposing discipline where sexual harassment has occurred. Even and not to undermine the incident here, but even where there's been no physical element of it, like there's purely verbal sexual harassment in this case. And then, secondly, it's a good contextual assessment by the arbitrator of not taking for granted that because something happened on the picket line or during a work stoppage, that it's a mitigating circumstance automatically. He seems to be suggesting that the union needed to demonstrate there was a correlation between the fact that this employee was on a picket line as a justification for the misconduct in question. So, with that, I will pass it over to Erin, I believe, for the next case on point.
Great. Thanks, Jordan. So my case doesn't have the same ending as Jordan's, unfortunately. And it does, it's unique in that it comes out of minutes of settlement that were resolving an unfair labor practice dispute. And so this is with the Canadian Union of Public Employees, so CUPE, and the WSIB. And so as many of you in Ontario may know, there was a 6-week strike where the WSIB workers had gone out and, it was, as many strikes are, fairly contentious. And the union had filed, I believe, 2 different ULPs, unfair labor practices, with the labor board. And that was resolved by entering into minutes of settlement. And part of those minutes of settlement was an agreement that Barry Fishbane would be appointed as an arbitrator to determine the issue of a number of complaints that were filed by workers during the strike against the employees who were on strike. And so the employees who had crossed the picket line and remained at work during the strike had filed complaints under the WSIB's respectful workplace and code of conduct policies, suggesting that they had been subjected to harassment and intimidation by the employees who were out on strike. And there's some procedural discussion at the beginning of this case to talk about, okay, how will Fishbane actually deal with this? And is he investigating, or does he determine, is his role as an arbitrator? And ultimately, it's decided that he will do a threshold analysis of the complaints to see whether or not they could, if everything were true, could amount to harassment, and therefore warrant sort of further investigation under the employer's policies and under the Occupational Health and Safety Act. And in order to do this, he's given a number of emails and sort of screenshots of chat groups. And in there, and so he reviews that and ultimately determines that none of the complaints should be investigated, that they should all be dismissed. And he talks about the fact that a strike is not high tea at the Empress Hotel, so that there can be an expectation that there is going to be some behavior that scabs would feel uncomfortable with, and that they may think is unpleasant behavior towards them. And he said that's sort of par for the course when you're dealing with a strike. And so, while I can get behind that general proposition that, often there can be heated exchanges during strikes, and that perhaps some behavior that would normally not be acceptable in a workplace is given a little more leeway when employees are off on strike, I do think that there was perhaps a line crossed, which arbitrator Fishbane doesn't seem all that concerned, or wasn't all that concerned about. And so some of the examples I've put here on the slide in the chats or on emails, they posted a picture of a burning house where they said, "I'm not saying I support burning anyone's houses down, but..." And, the arbitrator dismissed it just as being hyperbole. And so clearly it was an exaggerated statement and not actually intended to mean anything. And then there was another comment about, "I'm sure what we're legally allowed to do to scabs, offering them a quick trip down a flight of stairs, probably is off the table." And so again, the arbitrator sort of dismissed that, saying, "Oh, well, clearly that's a joke. Maybe it's a bad joke or was made in bad taste, but it was just a joke." And then there's another joke about using drones, and suggesting that Ukraine had great success in using drones, and therefore perhaps they too could use drones to sort of penalize the people who had crossed the picket line. And the discussion around that is very sort of dismissive, to suggest that that behavior is acceptable and just part of the normal course. And arbitrator Fishbane says that this was all done virtually. So unlike in the case that Jordan was talking about, where it was actually on a physical picket line, here, because it was done virtually, either through email or, in chat rooms, that the employees who are complaining could just ignore it. So you can just delete an email, or you can just, unfollow the chat room. And he talks about the fact that no one was forcing them to be in the chat room. So, if they were in the wrong place, if they weren't there, then they wouldn't have seen all of these things that people were saying about them. And you could just, quote unquote, turn your computer off if you were unhappy with what people were saying. And to me, that seems like that is a fairly antiquated way of looking at harassment, and not recognizing that harassment now, particularly over forms of social media and through email and chat rooms and things like that, is quite real and can have quite a significant impact on people. And so to sort of diminish the effect of this simply because it was done virtually, I think is fairly dated. And certainly there's a case, and I believe we talked about the case last year, when it went to the divisional court, and now it's gone to the Court of Appeal, and that's the Metrolinx ATU case. And you may recall that in that case, a number of employees had engaged in a WhatsApp group chat where they were making disparaging comments about a supervisor. And somebody showed the supervisor the messages, and she became quite upset, although she didn't want to file a complaint personally. And so in that case, arbitrator Laborski said, essentially boys will be boys, which, it's a bad decision when the arbitrator is using that as its reasoning, but that boys will be boys, and there was no intent that these comments got out. And they weren't really part of the workplace. They were part of a private conversation. And the divisional court and then the Court of Appeal overturned that decision, saying that once these sort of virtual messages are shared with people in the workplace, then it very much does become part of the workplace, and that an employer, in fact, does have an obligation to protect people from these types of harassment. And so in my mind, I think when you're just stepping back and you're looking at allegations of harassment and what to do with social media or with comments that are being, given to people virtually, that you should be thinking about the decision from the Court of Appeal in the Metrolinx case, rather than sort of relying on Fishbane's opinion that, well, one can just turn their computer off and therefore it's not harassment. But ultimately, what we take from this decision is that there is certainly more leniency for behavior on a picket line than there would be if it were occurring within the workplace. And Fishbane does acknowledge that some of this behavior may have crossed the line and been in breach of policy if it had just been in the traditional workplace rather than behavior that was occurring in the context of a 6-week strike. So now over to Quebec.
Great. Thank you, Erin. The decision I'll be speaking about today is not in a context of a labor conflict like the decisions that Erin and Jordan have just mentioned, but rather in a situation of day-to-day union activities. So this decision is Fortin against Réseau de Transport de la Capitale, which is the public transit system in Quebec City. So recently the board rendered a decision in which it overturned a 3-month unpaid suspension that the employer had imposed on the union's president for harassing other employees. The employer's decision to suspend the union president for 3 months had followed an external investigation that they had mandated, which had found that the union president had harassed other members of the executive, while all the individuals involved were fully released from their regular duties with the employer for their union work. The members of the union executive who felt like they had been harassed by the union president had sought help from the union to put an end to the situation. But when the union did not act or seek to remedy the situation, the members of the executive turned to the employer to seek some assistance. The employer believes that this situation fell within its obligation to prevent and to cease situations of harassment when they're brought to their attention, because it involved all employees and it also had occurred within the workplace. The union president and the union contested the suspension before the labor board, claiming that it was illegal interference with union activities pursuant to the labor code. In its decision, the board found that the employer could not discipline a union officer for how she performed duties. The board explained that the alleged misconduct occurred strictly within union activities, so not while the president acted as an employee, because she was released full-time for her union duties. The board explained that investigating internal union conflicts under alleged harassment prevention constituted illegal interference with union autonomy. The board then went on to explain that the employer's obligations under the Labor Standards Act to prevent and put an end to situations of harassment that are brought to its attention do not override freedom of association or allow control over union activities. So the board found that the employer should have instructed the complainant to file a complaint with the union, which is quite surprising considering that they had already done so, and that was the reason why they were going to the employer to seek some assistance. So in its decision, the board upheld the complaints, annulled the suspension, and the employer was ordered to reimburse lost wages, but also a series of various moral, so non-pecuniary damages, and also punitive damages to both the union and the employee. They also ordered the employer to post the decision in the workplace for 30 days and on its website as well. This decision could establish a very delicate precedent because it puts employers in a difficult situation where they have to decide between their obligation to ensure the protection, prevent harassment in the workplace, and also respect union autonomy. So not surprisingly in this situation, the employer has sought judicial review of this case. So we'll see what happens in the Superior Court with this decision. Now I'll pass it back to Jordan for freedom of association decisions.
Yes, thank you, Emilie. So the first decision involving the union's freedom of association rights we're looking at is a decision from the 2025 decision from the BC Labor Board. And the parties on the citation are noted as Gateway Casinos and the BC General Employees Union and the Attorney General of BC. But, you know, if you do look up the decision, about 10 other unions and some businesses, including an employer coalition, got involved in this case as interveners due to the importance of the issue within the province generally. So this is, as I mentioned, this is a 2025 recent decision of the Labor Board, and it dealt with a challenge to the secondary site picketing restrictions that are under the BC Labor Code. And in particular, the union alleging that those provisions are an unlawful interference with their charter rights, namely the freedoms of expression and freedom of association. And so the decision itself actually stems from a dated work stoppage that occurred back in 2019. And the hearing was held back in 2020 as well. But because the work stoppage resolved, the board, I guess, didn't feel compelled to issue the decision in a timely manner. So it was just released earlier this year. By way of quick background, what underpinned all of this is that the BCGEU went on strike at 4 Gateway-run casinos in the interior of BC, so Kamloops, Penticton, Kelowna, and Vernon. All 4 of those casinos operate under the same single certification granted by the board. The primary dispute at the time related to wages, and in particular, the BCGEU trying to wage match the wages that they obtain for their members working at other casinos in the Lower Mainland, but getting that same level of wages for employees working in the interior, where historically cost of living has been lower. So bargaining really broke down on the basis of the disagreement on wages, and a numbering of picketing related issues arose, including the union asserting that it ought to be able to picket at the employer's secondary non-struck locations. The basis of the union's argument is that such picketing would be essential to achieve the economic and bargaining leverage that the picketing and strike provisions of the code generally contemplate. And this prohibition on secondary picketing is therefore a violation of the freedom of association under the charter. All of this resulted in, as I said, the GEU taking the position before the board that really the secondary picketing prohibition in BC is unconstitutional as a violation of charter rights. And so the provision in question, the provisions in question are found under Section 65 of the BC Labor Code. Section 65.3, and I'm just, again, kind of summarizing this, what is a long provision, it essentially says a union or members of a union which are lawfully on strike or lockout may picket at or near a site or place where a member of the union performs work under the control or direction of the employer. And then Section 65.8 of the code provides that for the purposes of this section, a division or other parts of a corporation, if they are separate and distinct operations, must be treated as separate employers. And so that's really kind of the genesis of the secondary picketing prohibition in BC. It's because the picketing section generally here says that, even though it's the same company, if you have 2 locations in BC and they're separately certified and have separate collective agreements, the union cannot picket the other site that is on strike or lockout. And so, the one exception to this provision is where the labor board determines that a secondary employer is acting as a what's referred to as an ally, where that secondary employer is giving the primary employer some sort of undue assistance in order to alleviate the economic pressures of the strike. And so in terms of the decision, the union's application was dismissed by the board, which is obviously a win for employers. The board acknowledged that the right to picket is a protected charter right, and it found the right to picket but it found that the right to picket locations that are not part of the bargaining unit and are not directly involved in the bargaining dispute are not covered by that charter right. The board provided a coherent and kind of historical summary of the balance that's been struck by the BC legislator as it relates to work stoppages in BC. And so BC is a bit unique in the sense that the code permits the union to place greater economic pressure on a struck employer via as we just talked about, the very broad replacement worker provisions. But at the same time, that occurs with less impact on British Columbians due to the counter restrictions on secondary site picketing that are found in the code. So the board said that this approach strikes a balance that permits unions to assert economic pressure on employers during a strike, but it does not unduly impact the employer's broader operation via non-struck workplaces or British Columbians generally. As it relates to the freedom of association piece, The board noted that, what the freedom of association protects is ensuring that the union has meaningful collective bargaining, and that will occur. The freedom of association or charter rights generally do not extend to specific bargaining outcomes. And so the board noted as follows, quote, "The freedom of association protects the process of bargaining. Meaningful collective bargaining requires the parties to exchange and explain positions, but it does not impose on them an obligation to conclude a collective agreement or accept specific contractual provisions." And then keep in mind, what was underpinning this work stoppage and the strike was ultimately a disagreement on wages. And so, what we're seeing from the board here is saying, the freedom of association cannot be used to compel the employer to agree with the union's wage proposal. It simply requires the parties to engage in good faith bargaining and meaningful bargaining. So in terms of, takeaways, obviously this decision, it's unique to employers with multiple unionized sites in the province. But like I said, I think employers can definitely think of this case as a big win. It reconfirms the principles in the code that secondary site picketing is not permitted in BC unless the union can show that, a secondary employer is acting like an ally for the purposes of the code. And while this has been and remains the law in BC, it comes at a very welcome time on the heels of the additional economic pressures behind the recent, expanded application of the replacement worker legislation, and also, generally the very union-friendly amendments to the labor code we've seen in the last several years in BC as well. And with that, I will pass it over to Erin.
Thanks. And I think one of the themes that you've probably noted, and something that Emilie touched on at the very beginning, is that we're seeing an increase in the number of strikes over the last couple of years, that there are more labor disruptions than there have been, certainly in the recent past. And that can likely be attributed to sort of the economic uncertainties and economic climate that we're facing. And so there is also a case from Ontario from the Court of Appeal with the ATU and the TTC. And in this case, the union was challenging the constitutionality of the TTC Act, and the TTC Act essentially took away the right to strike and the TTC's right to lock out workers, and instead mandated that they go to binding interest arbitration as a form of dispute resolution. And this legislation was passed in 2011 and had been, obviously in place for just over a decade at the time that it was challenged. And one of the things that the union was relying upon was the fact that they said it has had an impact on our ability to bargain. Because if you look at the bargaining that we've tried to do since this legislation was introduced, you can see that, that the union hasn't been able to be successful, or hasn't been able to sort of exert pressure in the way to get deals that it might have in the past. And while the employer disputed that, I think that was something that was persuasive, or one of the persuasive factors that was being considered when looking at the constitutionality of this legislation. And the decision talks about whether or not there was a violation of Section 2D of the Charter, so the freedom of association provisions. And it sort of reaffirmed that there are two questions to be asked. Does the legislation interfere with the activities protected under 2D? And so again, the union had put forward evidence suggesting that in fact the TTC Act was interfering with their freedom of association. And then does it substantially interfere with those rights? And then if the answer to these questions are yes, then you go into the Section 1 analysis, and can it be saved when you look at the Oakes test. And the court determined that any sort of legislation that takes away the right to strike would be automatically a violation of the charter and of your Section 2 freedom of association rights. And they said that really the focus of these cases is on whether or not it can be saved under Section 1. And so under Section 1, of course, you look to whether or not there's a pressing and substantial objective. So, is preventing harm? Can you demonstrate that there would be sufficient harm if the TTC were allowed to go on strike? And then is the legislation impairing the right to strike or the right to freedom of association as minimally as possible? And here the court said that the government didn't actually consider whether there were any sort of less invasive ways of achieving the same result. So could you have partial strike bans? Could there be some sort of proportional response that didn't take away the absolute right to strike, but rather looked at it through a different lens? And so ultimately they decide that the TTC Act was unconstitutional and struck it down. Now, I think it's interesting that in this case, the Justin Nordheimer wrote a dissent, and in that he said that the TTC is an essential service, and there's actually quite a bit of evidence that demonstrates that there is societal harm, particularly to lower socioeconomic classes and disabled groups, if you take away the right to that public transportation, because it limits people's ability to get to work, to get to medical appointments, to get, just to travel within their community. And so the dissent talks about the fact that something like a public transit system should be given the same sort of protections as other essential services, such as hospitals or long-term care homes, that do take away the right to strike and have this automatic mandatory arbitration. But there's another decision that came out at the same time for the Ontario Teachers College, the College of Applied Arts. In any event, they had been on strike for about 5 weeks, and new legislation was introduced that ordered them back to work. And that was upheld under the similar sort of analysis, looking at Section 2D and Section 1 and can it be saved. And the difference there seems to be whether or not there is this preemptive ban on the right to strike, or whether it is back to work to legislation. And the courts seem to be much more open to upholding this back to work legislation by then being able to look at the actual facts and what evidence can be put forward about harm, rather than sort of just presupposing that harm could occur if a certain industry or organization is allowed to go on strike. So that's been what some of the cases that have dealt with freedom of association in Ontario over the last year. Emilie, over to you.
Great. Thank you, Erin. In this section of the presentation, I'll be speaking about an arbitration decision in which the arbitrator was asked or had to decide between union activities, which are related to the freedom of association rights, and the employer's exercise of management rights in relation to its operational needs. So in this particular case, Société Québécoise de Récupération et de Recyclage, the employer is a state corporation subject to both Quebec and Canadian charters. The employer here had authorized a first full-time union leave of 10 months for an employee in order for her to occupy a position with the union. The employer had to temporarily replace her by someone else during the period of her leave. However, during the leave, the union requested a 6-month extension of the employee's full-time leave, and the employer had refused, namely due to staff shortage and the impact on the other employees' workload. before the union filed grievances. Despite the employer's first refusal, the union requested a second 6-month extension in addition to the first extension. And again, the employer refused for the same reasons that I just mentioned. The union filed again 2 grievances for the employee and for the union. The employer was alleging that the collective agreement provided that the employer had discretion to authorize or decline a union leave, and that it had exercised its discretion in good faith and without anti-union sentiment. In the arbitrator's decision, the arbitrator found the collective agreement did not grant discretion to the employer, despite the use of key expressions like can benefit or following a request for permission to the employer, and therefore found that once the employee had filled the criteria that were mentioned, so requested a permission within 30 days before the leave and had indicated the start and end date of the leave, the employer had to grant the leave. And the arbitrator added and mentioned that even if she had found that the employer had discretion in granting the leave, the employer did not sufficiently demonstrate that it could not replace the employee during the leave. And the arbitrator found that the fact that the replacement worker who had been hired couldn't continue her replacement, her temporary contract, because she had to go on maternity leave, and the evidence relating to the difficulties in recruitment in Quebec was insufficient evidence in a context of freedom of association. Therefore, she found that considering the importance of freedom of association, the employer had to demonstrate that it had tried and could not replace the employee requesting the leave. It's unclear in the decision what level of effort to replace the employee would have been deemed sufficient by the arbitrator, but it appears from the decision that the freedom of association in the situation increased the threshold of evidence required from the employer when exercising a management right when it comes to union activities. So it'll be very interesting to see how this decision will be followed by subsequent arbitrators, since unions will likely be relying on this case for any refused union leaves as provided for in the collective agreements, even if the collective agreements provide for discretion and management rights to the employer in terms of authorizing or not authorizing the leaves. Now, just before we go to the next section, I just wanted to mention a few words on the new Bill 3, which was just recently presented by the Quebec government a few weeks ago. So this bill, I'm sure those in Quebec have already heard about this because the unions have been very vocal on how they feel about it, but it's a bill that aims to reform the union system by strengthening transparency and democracy within unions. So it does so by creating 2 separate categories of union dues. If this bill passes, it will provide for 2 types of union dues. There will be principal and optional dues. So principal dues are used for core union activities like negotiating and workplace representation. Principal dues will not be allowed to be changed unless authorized by a majority vote by employees, by members. Then there are optional dues, which would be used for other non-core activities, such as legal challenges, ad campaigns, social movement participation. Principal dues will not be allowed to be used for these other non-core activities. And these optional dues will have to be submitted to a vote once a year to the members, who will have to determine whether they want to participate and pay into these optional dues. In addition to this new development in union dues, the new bill would provide that unions must present financial statements to members every year, and also that unions must present to its members a report on the use of their financial resources every year. And one of the elements that this report will have to provide for is the compensation, benefits, and certain expenses over a certain threshold of $5,000 for people who hold elective offices within the union. So this, as I mentioned, this bill has already been greatly contested by the unions in the media and on the streets. Consultations will start next week, so we will be probably hearing about this much more and maybe discussing it next year at our next year in review, depending on when this is passed. Now I'll pass it back to Jordan on communication of evidence.
Thank you, Emilie. Oh, looks like we have Erin's case first. I'll skip forward, Erin, and then you want to come back to? Yeah. Okay, there we go. So the next topic we're looking at is kind of some changes in terms of disclosure of, we refer to it as, particulars in BC, as well as the production of documents in the arbitration context. Historically, I guess I would say, sometimes these types of disclosure have been relatively, laxed in the labor arbitration context, and we are seeing a trend a bit more towards a more formal process in terms of the production of documents and information about each side's case and position, more so well advance of upcoming hearings now. So the first decision we're looking at is one from a recent one from BC, actually argued by our colleague in Vancouver, Clayton Jones, where he obtained a very favorable outcome for the employer in that case. So the case name here is, Jack Suey and Heidelberg, and the union involved is the Teamsters, Local 213. By way of quick background here, what led to this case was that the union filed a grievance alleging that the employers had violated the collective agreement by bypassing dependent contractors during a gravel haul from one of the employer's locations, contrary to the work assignment provisions in the collective agreement. The union claimed that 5 dependent contractors had lost work during this period and made a claim for, or filed a grievance for compensatory relief for that lost work. The employers obtained an order from the arbitrator requiring the union to provide certain information and documents relating to the allegations in the grievance. And as the union was seeking a make whole remedy for the lost work, the employers also sought information regarding number one, what days the dependent contractors say they were available to perform this work, and number two, information regarding any mitigation efforts of the dependent contractors for those respective days. The arbitrator did grant the employer's order and required the union to provide documents and additional particulars of its case and position by November 18th. This was last year, November 18th, 2024. The union obtained 2 additional extensions after this until December 10th. And on this date, the union's disclosure and particulars were still considered substantially deficient from what the order required. So this actually led to the employers bringing an application to have the arbitrator dismiss the grievance. The arbitrator agreed, and he did agree to dismiss the grievance. He really summarized kind of the approach in this quote here. I understand and accept that the union has a legitimate concern about losing a chance to vindicate its position. Dismissal is a serious outcome. However, I have now taken the following incremental steps to address this matter and preserve the integrity of the proceeding. First, I encourage communication and cooperation between the parties. Second, I obtained written and oral submissions on disclosure. Third, I formally defined clear disclosure and production requirements. And fourth, I granted 2 generous extensions following the aggriever's apparent lack of cooperation. The arbitrator then went on to say the grievers have been given ample time to respond and comply. There is no adequate explanation for noncompliance, and I do not see a practical, lesser alternative to ensuring a fair hearing in these circumstances, aside from dismissal. And so, we have a provision in the BC Labor Code, it's Section 88, which requires, arbitrators who are appointed to hear grievances to hold a case management conference within 30 days of their appointment. And one of the requirements in holding that conference is to ensure that the scheduling and exchange of particulars and documents is set. This is not always kind of strictly adhered to. And a lot of the times parties are just given discretion in terms of disclosure of documents and particulars deadlines. And so I think, the takeaway here is, like I said in the intro, there's certainly a growing trend of arbitrators taking a more formal approach to pre-hearing and disclosure matters. And it's also a very good example of the potential very significant consequences of non-compliance failure, and really, shows a move away from how things may have historically operated in labor arbitrations, and sometimes still do, where you're seeing documents and information for the first time at the outset of the hearing, or once the hearing's already commenced. So a bit of a move towards the more formal type disclosure requirements you might see in court litigation process. And so I'll pass it, I think, over to Erin at this point, and I'll let you do the slides, Erin. Yeah.
Thanks. So the case that I'm going to talk about is out of Thunder Bay. And this is a case where the union brought a grievance, and they brought it as a policy grievance, alleging that employees were not receiving the benefits that they were entitled to under the collective agreement. And they based this generalization on the fact that there had been a couple of examples of a few employees who may not have received appropriate sort of reimbursement for some benefit services. So whether it be, physiotherapists claims or things of that nature. But they didn't, or at least in this case, they weren't addressing individual grievances. As I said, they were dealing with it sort of as this general policy that grievance that they wanted an answer to. And so as a result, they sought production of any instance where an employee had been denied either full or partial coverage for any health benefit over the past 3 years, which of course could be an extraordinary amount of documentation. There were just under 400 employees within this bargaining unit. And so the employer objected to this production request and said that it was, in essence, a fishing expedition, and that the union was just looking for the employer or the insurer at the behest of the employer to go through and to have to sort of comb through their documents to see if there had been any breaches. And the employer suggested that it wasn't their job or the insurer's job to do that, but the union had to come forth with relevant particulars. And then they also made an argument that the insurer, they weren't themselves in control of the documentation. It wasn't within their possession, but rather in the possession of a third party, being the insurer. And then they also made a complaint saying that they were prevented from producing this information because of privacy concerns. So naturally, benefit information would contain very sensitive medical information, and therefore shouldn't just be disclosed at large, but rather needed to be much more particularized in order for the employer to have an obligation to request and then disclose that. And the arbitrator agreed in part with the employer. So first, the arbitrator said that the grievance had been filed in a manner that was overly broad, so that the union had an obligation not only to demonstrate that the documents were relevant, but also that there was a reasonable ground to believe that there was a violation of the collective agreement. And just sort of this broad assertion wasn't going to be sufficient in order to do that. And the employer had suggested that it would be very time-consuming and costly to either to have it or to have the insurer go through and try and pull all of this information. in that case, the arbitrator said maybe, and that might be a reason to deny the production request on the grounds that it wasn't reasonable. However, no evidence was led to actually support that assertion. So if you're going to try and rely on that, you're going to have to put in more evidence about what the actual time it would take to pull that documentation. Because the arbitrator said, for all I know, you could just click in a date range and you might be able to pull that data quite easily. So more information was needed there. And then the arbitrator turned to the privacy concerns, and there had said that there were legitimate privacy concerns, that every employee within the bargaining unit who had submitted a claim within the last 3 years could have their medical information shared without their knowledge and without their consent. And so what arbitrator Bendel did was say, well, if the union wants this information, it has to get a consent from every employee before any of the information is disclosed. And they also have to provide as much detail as possible about which claim was denied and what the circumstances of that claim was. So although the union was going to get some form of production order, I thought that this was actually a creative way for arbitrator Bendel to narrow the scope and put some of that onus back on the union, which I think was a roundabout way of answering the employer's objection that this was just a general fishing expedition and that the union was being overly broad in its request for information, and that it wasn't appropriate to just ask for 3 years worth of information as a starting point. And so then forcing the union to go and actually collect information from the employees about claims that they had that were denied would presumably narrow the scope quite significantly of the information being provided. And then also ensure that proper consent was obtained prior to having that information released. And I know I had a case with ONA where we were fighting over benefit information, again, for a very large portion of the bargaining unit. And the insurer in that case simply refused to provide the information without employee consent. Now, perhaps if the arbitrator had ordered it, then that would have been different. But the same result sort of occurred in that case, where the union then had to go back and gain individual consent from every single person before we would then go to the insurer and have the insurer provide the relevant documentation. And then finally, of note, the arbitrator said, look, even though the documentation is within the control of the insurer and it's the third-party insurer's information, it still is determined to overall be in the control of the employer. And he placed the onus on the employer to gather that information rather than the union seeking it through the insurer. And so for the final commentary, I will pass it back to Emilie one more time.
Great. Thank you, Erin. For this section, I will again speak about a new bill in Quebec in labor relations. So here I'll be speaking about Bill 101, which received assent a few weeks ago, just on October 28th. This new bill provides for modifications in various labor laws in Quebec, but the ones that I'll be speaking to about today are the modifications to the labor code, which aim to accelerate the grievance process, the grievance arbitration process, and also try to prevent huge grievance backlogs that certain employers experience. So these new rules provide that if an arbitrator is not designated by the party who has filed the grievance within 6 months, the party who filed the grievance must request in the following 10 days of the end of that 6-month period that the minister nominate an arbitrator. And if the party who filed the grievance does not complete those steps, the grievance will be deemed discontinued, Obviously, the party will have the opportunity to explain if there's any extraordinary circumstances that explain the fact that they were not able to respect those delays. But this is a significant shift in labor law in Quebec. Another element that the bill provides for a significant shift is that evidence and list of witnesses will have to be communicated to the arbitrator and the opposing party at least 30 days before the hearing. And here there's an exception that provides for except in urgent situations or unless otherwise decided to ensure the proper administration of justice. So the rules relating to the communication of evidence will apply to grievances that are filed after October 28th, 2025. And these new communication rules obviously are a significant shift in labor arbitration in Quebec. Similarly to what Jordan was mentioning about arbitration in BC, in Quebec, there's also been a longstanding practice where often evidence will be presented for the first time the day of the hearing. And obviously, this is especially the case when they're in disciplinary files where testing the credibility of witnesses is one of the important elements of evidence. The new bill regarding the portion of the bill on communication of evidence will also, we believe, lead to very interesting debates during preparatory conference calls. So obviously these exceptions will have to be debated, will have to be decided, and we will be able to let you know how those discussions and what the practices are that evolve out of that. And so obviously this modification regarding communication of evidence raises a series of questions. One, obviously, how will these exceptions be treated by arbitrators? And also, will a party need to communicate all of its evidence? Let's say there's a multi-day hearing that may go on for a number of months or maybe even more than a year. Will the party who is communicating evidence have to communicate the entirety of their evidence before the first day of hearing, or is it just communication of all the evidence that will be produced on that first day of hearing, and then so on and so forth for the subsequent days? It is likely, I think, that they will be requesting communication of the entirety of the evidence. As I mentioned at the beginning, one of the objectives of this new bill, this new rule, is to accelerate arbitration processes. So it is anticipated that arbitrators will likely decide in that sense. And also regarding the application of those exceptions, so proper administration of justice exception, will evidence used to test the credibility of a witness fall within that exception? Again, we'll be able to tell you in time how these exceptions will be addressed and decided by the arbitrators, and we'll likely be able to give you an update next year during our year in review. So I will hand it back to Erin for the end of our presentation.
Great. Thank you so much. And we've come to our end of the time today. You can see on your screen the QR codes for your CPD credits, and there are credits offered in Ontario, Quebec, and British Columbia. Links have also been added in the chat. If you don't get a chance to get your certificate today, they will be sent out to you next week. We encourage you to sign up for next week's seminar, Navigating the Duty to Accommodate in the Canadian Workplace, and that takes place on November 25th. A link to register has been added to the audience chat, and you can also find it on fasken.com. Thanks again for joining us today. We hope to see you at another session soon, and enjoy the rest of your day.